Have you ever considered the question of whether you should be forced to belong to a labor union? If you happen to work in a particular trade, should the law be able to force you to join a union? Mark Mix is joining me now, president of the National Right to Work Legal Defense Fund. Mark, it's good to have you back on the program.
Lars, it's good to be with you, although I wish it were under better circumstances. It seems like just about everything's on fire these days.
Absolutely. And, of course, we have a major election going on right now. But I want you to describe to people what has happened to home health care workers after the passage of a law that forced them to belong to a labor union.
Yeah, Lars, this is a very unfortunate case. It's a situation where the state of Oregon and the Service Employees International Union Local out there in Oregon that claims to represent these people is basically disregarding a Supreme Court decision from back in June of 2014 that was litigated by the National Right to Work Legal Defense Foundation that basically said these home care providers and daycare providers and other kind of partial, if you will, state employees of the state for purposes of forcing them into these union collectives, can't be forced to pay dues or fees to work and do their jobs. But yet the state of Oregon and the SEIU local out there will not allow these people to get out and exercise their constitutional rights. And so working with the Freedom Foundation that has an office up in Seattle and then one there in Oregon with you, we have filed a lawsuit on behalf of these providers to basically get the state and the SEIU local to adhere to a Supreme Court ruling from 2014 that says they can't do what they're doing.
Just so people understand, Mark, my dad was a state park worker. Okay, he worked for the state parks department, so he drew a paycheck from the state. But when we describe these home health care workers as sort of state employees, that means, and correct me if I'm wrong on this, somebody out there needs, say, some home care help because they're either temporarily disabled or because they're older. So they get these benefits and they're allowed to spend them to hire somebody to provide care for them at home. It might be help making, doing their clothes, washing their clothes, or making food, or getting in and out of bed, that sort of thing. Those are the people we're talking about. And those people, while they're hired with dollars that were provided by the state, they're hired by the person they're caring for, correct?
Yeah, that's exactly right. And that was the issue in the Harris case that the Supreme Court looked at in 2014. The recipients of this care were receiving a stipend from the state so they could be taken care of in their home. And the fact that a provider, in the case of our plaintiffs in the Harris case in 2014, these were mothers, Lars, who were taking care of their own children, who were forced to pay a fee to the SEIU in Illinois to take care of their own children in their own home.
All right. So what you're fighting for in this latest lawsuit is to break that and say these people should not be forced to join a union, pay dues. Some of their dues might be spent for political purposes, the rest of their dues ostensibly for negotiation. But these people should be able to provide that kind of care without being forced to join a union.
Well, Lars, we've actually already won that battle. This is just getting the union and the state of Oregon to recognize what the Supreme Court said they had to do, to recognize the constitutional rights of these individuals. I mean, it is not a question of law. It's a question of will the union and will the state of Oregon stop collecting these fees from workers who say they don't want to be in the union. And up to this point, the plaintiffs in this case and literally hundreds, if not thousands more Oregon employees similarly situated are being compelled to pay this fee. The state's taking the money out of these stipends, and they're forwarding it to the union. And the state literally says, Lars, they're waiting for the union to instruct them as to how to proceed.
Hold on. So the U.S. Supreme Court, and I guess I'm forced to bring up the example of the gay marriage decision and the county clerk in Kentucky, where the Supreme Court said, look, this is what the new law of the land is. So the Supreme Court has spoken in this union case, and the state of Oregon is saying, oh, we really don't know how to comply with a Supreme Court decision until the union that was the loser in the Supreme Court decision tells us how to do it?
That's exactly the way this has turned out, and it's really an amazing thing. I mean, literally, there's no question about the rights that these workers have. It is a constitutional right these workers have, and you think, Lars, the state and all those elected officials that stand up there and say, I uphold the Constitution of the state of Oregon, or whatever it is they oath to when they get elected, you'd think they'd understand this, but apparently they're waiting for instructions from the union officials who are receiving this money over the objection of the workers they claim to represent.
And let me guess, I shouldn't hold my breath waiting for the union to tell the state to stop taking the dues out of the workers' paychecks.
Yeah, I think that's right, and the fact that we have to litigate it is enough of a evidence to that fact. In fact, filing the lawsuit yesterday, working with the Freedom Foundation out there, Tom McCabe and his team, we're anticipating they'll get 30 days to answer the charge, and they'll probably get an extension because of Christmas and Thanksgiving, so it'll pour over into next year. They'll answer it. We'll have to respond to that. They'll ask for a summary judgment to dismiss. It'll have to be appealed. I mean, the legal process probably will drag on, but in the meantime, hundreds, if not thousands of workers will have this money extracted because the state's waiting for the union to instruct them as to how to proceed.
Now, I'm not a lawyer, Mark, but isn't there a thing called a writ of mandamus when a state agency or a government agency refuses to enforce the law that's on the books? I mean, isn't there some simpler way to force the state to do what the Supreme Court has told them to do?
Well, there is. There absolutely is. And I'm not a lawyer either, Lars. We've got enough of them back here and enough of them across the country. But the bottom line is you're right. We have used a writ of mandamus, interestingly enough, back here in Washington to get the National Labor Relations Board to act on cases that have been held over for 6 or 7 years. I think what the courts look for with mandamus, and obviously I'm not speaking for judges out there, but generally they're looking for this delay that occurs, this timeline that rolls on and on and on. In this case, it's really not an issue of fact. The fact is these workers have this constitutional protection, and the state of Oregon and the union are continuing to take this money out over their objection. It's really frustrating.
Unbelievable. Mark, thank you very much. I appreciate you taking the time.
My pleasure, Lars. Thanks for what you do.
Glad to have you on. Mark Mix, who's the president of the National Right to Work Legal Defense Foundation.